This was a hot button issue in the spring of last year, and we actually had some calls with the IRS about this issue. And we haven't gotten anything in writing from them, unfortunately, but it is a difficult issue. But where we got in them in our verbal discussions was that Section 42 has a reasonable cause provision in it.
Welcome to BuzzHouse, a Baker Tilly podcast where you can find all the buzz around multifamily housing. I'm Don Bernards, the partner in charge of Baker Tilly's multifamily housing practice.
And I'm Garrett Gibson, a partner at Baker Tilly, also specializing in consulting on multifamily housing transactions across the country.
Each week, we'll bring you a guest or a topic in the multifamily housing industry that will help you win now and anticipate tomorrow. Let's get started. Today, our guest in the BuzzHouse is our good friend and a very good friend of the industry. Many of you will know Glenn Graff with the law firm of Applegate and Thorne Thompson. Very happy to have Glenn here with us today. We're going to be talking with Glenn about hot button issues dealing with affordable housing and the IRS. Very, very excited to hear from Glenn as he is fresh off the IRS hearing on average income. So he's going to be able to speak about what he heard yesterday, as well as a handful of other current topics. Before jumping in with Glenn, we want to give you a few updates from around the industry. A few quick snippets to start out with. The IRS recently released the 2021 resident population figures for determining states' housing credit and private activity volume bonds, of course. For 2021, the credit allocation is the greater of $2.8125 multiplied by the state's population, or the minimum small state of 3.2 million. On the bond side, the allocation for 2021 is $110, of course, per capita multiplied by the state's population, or about the small state of $325 million. We know we've had a lot of discussion, of course, on the BuzzHouse about many states running on a volume cap. So I would kind of continue to stay tuned and watching that. Also, quickly, Fannie Mae and Freddie Mac are keeping forbearance measures in place going now through June of 2021. This, of course, as many reports noting, almost 9 million renters, give or take, behind on rent payments during this winter and early spring. Kind of exciting news from Fannie Mae. Earlier this month, to address the increased need for affordable housing, Fannie Mae introduced what is called the Sponsor-Initiated Affordable Incentives Program for multifamily borrowers. The goal here is to really preserve naturally occurring affordable housing and encouraging owners to restrict 20% of their units to residents earning less than 80% of the area median income. So really, again, sponsor-initiated or self-initiated restrictions on your property to long-term rent restrict, and it's rent and income restrict these units. It would require some type of affordability agreement. It would require some type of annual certification. And of course, the incentive will be lower interest rates, lower borrowing costs. So very much look forward to seeing this rolling out. Just announced, so we're not sure exactly when it's going to hit the street, but we'll give updates on the BuzzHouse as we learn more. This past month, the National Low-Income Housing Coalition issued their annual report. It's a report that I know Garrick and I look at throughout the year. It's called The Gap, a Shortage of Affordable Homes. And of course, as you all know, the gap is significant and huge for extremely low-income renters, almost 7 million units short of housing. On a similar fact, only 37 affordable units exist for every 100 very low-income households. And this is before the COVID impact. So I'm sure that number is even greater. So just a lot of data in there to taking and showing, and we all know it, but it just a very good report by NHLI, National Low-Income Housing Coalition. One last note, really what a lot of people are focusing on now in Washington, D.C. is what's going to happen with the infrastructure package. We hear a lot of hubbub about what could be in the infrastructure package. Obviously, roads and bridges, some other domestic priorities with the Biden administration. We all know in the housing industry that many things around the Affordable Housing Improvement Act could be part of that. So really, we'll be watching that closely here the next number of months to see what can get through. Again, could there be an increase of 9% allocations? The IRS giving states the authority to give basis boosts to all 4% projects like they have for 9% deals. We'll be very interested to kind of follow this legislation. So a lot more to come on this. Now, Garrick and I are very excited to jump into our discussion with Glenn Graff. Garrick?
Thanks, Don, and thanks for those updates. Always interesting to hear what's going on out in the industry. And thanks for coming on BuzzHouse, Glenn. We really appreciate it. You're definitely a titan in the industry. as far as I'm concerned. Well, why don't you go ahead and, for our listeners who are not familiar with you or Applegate, why don't you start out by telling our listeners a little bit about yourself and your firm?
Sure. Happy to be here. It's great to talk with you, Garrett, and you, Don. Wonderful to work with you guys again. So I'm a tax attorney. I focus primarily on affordable housing and community development. Most of the work I do is in the local housing tax credit area. I also do some historic credits, opportunity zones, a little bit of energy work. And the firm represents developers, investors, lenders, housing authorities. We get a good view of the industry because we work on all parts of it. And as the tax lawyer, I like to think that whoever I'm representing, the developer or the investor, I just shoot down the middle and give the answer I think is right. So that's my goal. I've been at Applegate and Thorne-Thompson for just had my 20th anniversary. I'm feeling very old. That was last week. I've been practicing for 30 years. I'm on the governing committee for the American Bar Association's Forum on Affordable Housing. And before I was on the governing committee, I was the chair or co-chair of the Tax Credit and Equity Financing Committee of the Forum on Affordable Housing, so for about 10 years. And we're also involved in other industry groups. So that it tells a little bit about what I do, what the firm does. The firm also does a lot of new markets credits. I don't do that as much. But we're very active and involved in anything having to do with affordable housing community development. That's our mission, and we're focused on it.
Yeah. Thanks for that introduction. We appreciate it. I obviously, our listeners listening to that understands that you have your hands in a lot of different things in this industry, for sure. So, and to that point, we know that, as Don mentioned, you just participated in the IRS hearing for the average income election proposed regulations, which we saw a large number of comments to at the end of 2020. We also know many projects that were underwritten as average income deals have come to a halt in the closing process or being underwritten without this election. I just recently had a project which they wanted us to change from the income averaging and put it back to just 60% AMIs. So can you give us your take on the hearing and the points of the proposed regulations that are the most troublesome?
Well, I think the thing that concerns, there's a few things that people are concerned by. One is, as we know, the average income provision allows projects to have some units above 60% of AMI, as long as their low income units average 60% AMI. So, for example, if let's say you had a 100-unit project, you might have 90 units right at 60% AMI, and then you might have 5 units at 80% and 5 units at 40%. When you do your average, you'd come out at 60% exactly. You would think that's great, no problems. In the IRS, the Internal Revenue Code says that the taxpayer designates the income levels for each unit in 10% increments. However, when the IRS came out with their regulations, they acknowledged the taxpayer designates them, but then they went to look at actual unit compliance to determine the average rather than just looking at the designation. So if in my example, one of my 40% units was misrented and was rented to someone at 50%, they would say that now your average is 90 units at 60, 5 at 80, 4 at 40, and 1 at 50. Even though I had designated 1 at 50 at 40, they would say that 1 at 50 counts as a 50. And now my average is over 60%, and that's a problem. And that is very worrisome to investors because, or that unit might even get removed is one of the options the IRS said is you can remove the unit. But if you take it out of the fraction, it doesn't work either now because I've got 90 right at 60 on the button and 4 at 40 and 5 at 90. My average is still too high. So that's very concerning to investors because you could end up losing credits. You could, in the way the IRS says it, is if your average isn't 60, then you've blown everything. It's a 100% failure because it's not just the minimum set aside. Do 40% of them. The code says it's a minimum set aside. Do 40% of the units comply with the designations? But the IRS says, well, if the average fails, you fail. Now, they gave some approaches to mitigate this, one of them being, well, you could turn a market rate unit into a low-income unit, or another one where you could remove, you'd have your unit that was at 40 that's rented at 50, you could, and it's out of compliance, you could take a unit out of your 80% units and take that out, and so not get credits on either one. So now you'd have 90 units at 60% and 4 at 40 and 4 at 90, you'd be again back at 60%. But now you've lost credits on 2 units. So that's bad. That's not a cataclysm, but that's bad. The cataclysm is they only gave you 60 days after the end of the year to do it. And that's a problem because I don't think what the IRS appreciated is that most of the issues that noncompliance come up are things people don't know about. It's, you rented units to tenants and you miscalculated their rent. Maybe you thought they were getting paid twice a month, but it's really every other week. And so their income was a little bit higher than you thought, or you had a pencil slip and you hit the wrong digit, or you miscalculated the utility allowance and you're a couple dollars over on a unit. Those are the kind of things that you don't find out until well after 60 days in the year. And then your opportunity to mitigate, what they call mitigation, would be gone. And now you'd be in a situation where you could have failed the minimum set aside. If you fail the minimum set aside, you lose all the credits for that tax year. And if the failure happens in the first year of the credit period, you lose all your credits forever. So it's a very disastrous result. So those are sort of the main concerns that people had. Also, the regulations stated that unit designations were fixed. You couldn't float your designations. So you'd have to say unit 1A is a 40, unit 2A is a 60, unit 3A is a 80, and you couldn't move those around. And so those were all concerns, and there were many comment letters that sent in. I worked with some of the leaders on the Tax Credit Equity Financing Committee for the ABA's Forum on Affordable Housing, and we sent in the letter. A bunch of other groups sent in letters trying to highlight these issues and suggest what we thought solutions were. So just sort of a recap, they did seem to get the floating unit issue. Well, it was a pretty powerful argument we had on that one because there are legal reasons you need to float units. If you have fair housing issues, you have somebody who gets hurt and they need to relocate from the third floor of a three-story walk-up to the first floor. Well, if they were in a 40% unit on the third floor and the only unit on the first floor is an 80% unit and you couldn't switch your designations, that's a problem. You can't actually comply with fair housing and with the rules. The Violence Against Women Act is also a similar one where maybe a woman who's threatened with violence needs to relocate. There are certain other issues, and the IRS got that. They said, yeah, you guys have made your case. We understand it. And again, they're very careful. Nowhere in this entire hearing did they promise to do anything. I mean, they're careful about that, and they don't think they have authority to make those decisions. They were invested. They asked a lot of questions. They were listening. We'll see what we get out of it. But they did say they actually, after like the fourth person brought up the floating, like, yeah, we understand. So that was good. So there was then quite a bit of discussions about how the percentage is computed, the 60% average that we talked about. Some groups had submitted comments that, you should just be able to find any group of units that is 40% of the project and it meets the 60% average, and then all the units qualify. And there were a number of questions IRS had about, well, what do you do with units that are not part of that 40? And that was a little bit unclear. The approach that the members of the committee that I worked with and I took and some other organizations took was not that approach. Our approach was more a close reading of the statute, which says that the taxpayer makes the designation. And we think once the taxpayer makes that designation, it just sticks. And so if I have 90 units at 60 and 5 at 40 and 5 at 80, that's it. Those are our designations forever. And we're at 60%, we're good. Now, if you have a unit out of compliance, you won't get credits on that unit. So if you rent a 40% unit at 50, you don't get credits on it. Just like if you have a 100% 40 at 60 deal, if you rent a unit out above 60, you don't get credits on that either. So we think the results should be the same there. It shouldn't impact the average. And that was discussed extensively. I think the IRS understood our position. They didn't say one way or another whether they agreed with it, but they understood that. There was also some discussions about casualties. Their position was if you have a casualty, that would cause a unit to fall out of the average also. So if one of my 40% units had a fire and it wasn't fixed by the end of the year, then that unit could fall out and again cause you to fail your minimum set aside. And that's explicit in an example in the regulations that's problematic. And so I made a point of discussing how, in my view, the designation should stick, and that as long as you are remediating the unit and under an approved plan by your credit agency, it should stay in the average. That doesn't mean you get credits on it because it's not habitable, it's not occupied. You might lose credits on it, but it's in the average, and so it won't cause you all on its own to fail a minimum set aside. They understood that. Maybe we'll get that. Hard to say. There was some discussion about effective dates. Maybe we'll have something where we go there. Maybe let it get effective for projects that you get allocations or bond assurances after the final regs. So those were sort of the prime highlights. It was a long hearing. It was, 4.5 hours, I think, or something like that. But I think it was productive, and it's good because the IRS treasurer are very careful that during comment periods, they won't talk to you privately because they feel it's unfair and needs to be public. And so this was really our only chance to have this sort of public discussion with them, and they were invested, so that was good.
That was really good information, and wow, yeah. I mean, the fair housing point. I mean, all the points you made. Just it seems very, very logical. Like you said, hopefully the IRS, Glenn, you might not. The answer might be we just don't know. Do we know when they could get back? I mean, what's the next step in the process?
At one point in an offline discussion, I asked them about would they withdraw the regulations, and they were like, "Well, that's pretty unusual to withdraw a regulation. They have the authority." That once they had a hearing that they can make changes based on any of the comment letters or any of that was proposed in the comments or during the hearing. And so I think it's unlikely, even though a number of people asked for the regulations just to be withdrawn and start from scratch, I think it's unlikely they'll be withdrawn. I think it's more likely that they'll some people did ask for a new round of proposed regs so there can be comment on them rather than go right to final. Maybe they'll do that. I don't know. It might just be they take these comments into consideration and go to final. I'm not sure. It would be nice if they went to another round of proposed so we can make sure they don't come out with final rules that really miss the mark. Don't know on timing. I mean, the IRS is not fast on things. It's 2021. And we got these regulations at the end of 2020. The law was changed at the end of 2017. Actually, in IRS times, 3 years, not all that long. So I don't know. If we got something this year, that would be pretty fast, in my opinion.
That'll be interesting to see what state housing agencies do with QAPs, and we don't have to dwell on this right now. But right, if we know investors are not investing in these deals, will state agencies say you're not allowed to do them? I think there has to be a lot more discussion in the industry. So we'll kind of keep our eyes on that. Glenn, I think we could talk all day on that. But switching gears during the pandemic, we know there's been delays and so forth, construction, lease up, things like that. So I think it was IRS Notice 2021-12. Which allows now for, to maybe not be dinged with 15-year credits if 2020 was going to be your first period in your delivering credits. Now you have till June 30th to lease those. What do you know about that, Glenn? What are you seeing? What's your kind of take on that notice 2021-12? And I think there was even maybe a follow-up or clarification on that. Yeah,
I mean, there was some initial. So what the new provision says is that it says for purposes of Section 42F, if the close of the first year of the credit period with respect to any building is on or after April 1st, 2020, and on or before June 30th of 2021, then the qualified basis for the building for the first year of the credit period is calculated by taking into account any increase in the number of loan units by the close of the 6-month period following the close of that first year. That was the original notice. So people were unsure exactly what that meant. One thing it seemed clear was that, to the extent you have a project and say its first year of credit period is 2020, and you aren't fully rented by the end of the year, but you fully rent after that, those units that are rented after that, they get 15-year credits. They get 2/3 credits for 15 years, and they miss the first year because the first year credit period is gone. So they get 14 years at 2/3 credits. And this said that if you get the units rented not by December 31, which is the regular rule, but during this COVID period, if you get them rented by June 30th, then it was pretty clear that meant you wouldn't have 2/3 credits. Your qualified basis at the end of the first year, which is actually what it's measured by, not by units, but by qualified basis. Qualified basis is eligible basis times your fraction. That your qualified basis would include that rental. So you'd be treated as, fully rented for qualified basis purposes at the end of 2020, and therefore no 15-year credits. What it didn't answer, what some people are like, well, does that mean I could get tax credits on vacant units that are rented by June? And that was unclear the way it was drafted, and it was a little unclear also because the regulation cited to Section 42F, which has a number of different provisions in it, but none of them really talk about occupancy. The only one that was clear was a subsection that refers to the 2/3 credits. And I actually had a discussion with Treasury about the issue and asked them for some clarity because some people were saying I could get credits in 2020 on a vacant unit, or maybe at least for December, because on December 31, maybe their deed is rented. And the comment I got back was, well, that would be generous to give credits on vacant units, and that their point in the subsection is headed extension to satisfy occupancy obligations. And while headings aren't binding on things, their state of mind was this was only a 2/3 credit issue, and that's what they were addressing. So they came out with a revision to this notice where they made it more specific that it's not just 42F, but to a specific subsection about the 2/3 credit. So I think it's pretty clear now that if you get the unit rented by June, that's a help. You will avoid 2/3 credits. You won't deliver any credits on a vacant unit in 2020, but those credits on the vacant units for 2020 will push back to the 11th year, like other first-year credits that you missed. So it's a help, but not a complete solve for all projects. There are some projects that will still suffer adjusters even after this, but they won't be as bad.
Well, that's definitely refreshing. I read that. That's kind of the take that I got out of it too. So, no surprises there. When we heard of the average income, everybody was all excited about it. And then reality hits in and the rules are there. And people got to kind of sit back and say, okay, how are we going to navigate this? So that kind of leads me sort of a segue into this sort of 4% credit rate that locked, at the end of December, where the rules came out and said, hey, fine, it's not a floating rate, it's 4%. There's a lot of great joy in the industry. Everybody was going, yeah, a lot of deals were saved. But of course, there were people who just closed their bond deals earlier in December or earlier. And, they're wondering if their project, which may have drawdown bonds, for instance, are eligible for this 4% fixed rate. Would you be able to comment on the discussion in the industry around this topic? Because it seems to be bouncing around and maybe you can shed some light on it.
Sure. So, just proving that Congress can't draft something that makes everybody happy. So this was a fantastic win for the industry. Getting the 4% fixed rate meant that projects could qualify for up to almost 30% more equity. The same project, just for moving the rate from like 3.09% to 4 is almost a 30% increase. So it's tremendous help to the industry, plugging many gaps in projects and reducing the needs. More credits means you might need less soft funding. The problem is that the effective date language that was put in was not the language that the industry had recommended, which was more be based on placement service, but they want focused on bond deals for when bonds are issued. So the language that they included for the effective date, first of all, any building that was placed in service before 2021 doesn't qualify. So that's a starting point. Building has to be placed in service after that. But it also says that either your allocation has to be after 2020 for 9% deals, because an acquisition credit on a 9% deal still gets the 4% rate on the acquisition. And the question is, does it get the floating rate or does this minimum apply? So if your carryover is issued after 2020 and you acquire the building after 2020, you could qualify for that fixed 4% rate on the acquisition. On the bond side, the big issue is the effective date says in the case of any, listen, in the word any is important. It comes up like 4 times in this. So in the case of any building, any portion of which is financed with an obligation described in 42H4A, and that's tax exempt bonds, any such building, if any such obligation which so finances such building is issued after December 31, 2020. So it's any. So any building, any portion of which is financed. So there is an issue, 2 issues that have come up that are very material is there's a structure called drawdown bonds. So you might have a project, say a $20 million project that's going to issue $10 million of bonds. And in 2020, you issue the bonds, but you don't draw all of the money from the lender at that time. You might draw $50,001 for technical tax reasons. And that activates the whole $10 million issue of bonds. It uses up the volume cap, the $10 million volume cap. But technically, other than for those volume cap purposes, for other tax purposes, the bonds aren't issued until you draw them. So if on your first draw you drew $50,001 in October, you'd have an issuance of $50,001 bonds in October of 2020. And let's say it's a $10 million bond. You draw $1 million a month after that. You never $1 million in November, $1 million in December. So then in December, you've drawn $2,050,001 in my example of bonds. But there are other $8 million of bonds, roughly $8 million, that wouldn't be drawn until 2021. And under these tax rules, because they're drawdown bonds, they wouldn't be issued till then. So the question is, in this language, which talks about, financed with an obligation described in 42H4, do you look at the date the bonds are actually issued for those other tax purposes? And there's actually a pretty good argument that that's the answer. The problem with that is that the understanding from the committee members who supported this, the four corners, they call them, the majority and the ranking members of the committees in the House and the Senate, was that they didn't want projects that are already penciled out under the old rules to work. If they already got their carryover, if they already had their bonds issued, they didn't want them getting the 4% rate. But they drafted some kind of loosey-goosey language that, in the end, the statute's what's important, not what somebody intended. We also don't have committee reports because this was done in a reconciliation process, so it was done quickly. And so we don't really have official legislative intent on it. So it's a little bit of statute probably is helpful, but the intent, that to the extent we understand it, not that helpful. The Joint Committee on Taxation generally puts out a blue book describing the statutes. We don't know what that'll say. So there's hesitancy among investors and others about would a drawdown bond deal that is still drawing bonds and therefore issuing them in 2021 qualify. So that's where that is. And it's hard because there's a lot at risk here. This is more than your typical adjusters, which are capped at 5%. You're talking about a 30% increase. I mean, in my example, a $20 million project could generate, $8 million of tax credits at a 4% rate. But, 30% of those maybe go away if you don't get to use that rate. So that's a multi-million-dollar adjuster and not something every developer can handle. So it's a difficult issue. The other issue that comes up is, well, what if I issued 10 million bonds? Let's say I drew them all last year. They're not drawdown bonds. Every dollar was used last year, but maybe I had some cost overruns. And now instead of my project being $20 million, it's $21 million. So my 10 million of bonds doesn't hit the 50% you need. So I'm going to float another $1 million of bonds in 2021. I'm going to hold tougher hearings and get a new issuance of bonds for another, actually it would be $500,000 that you need because $21 million extra cost, 50% of that is $10,500,000. So I need another $500,000 of bonds. Does that qualify now? Because now I have one bond issuance that is in 2021 clearly. And again, with the 4 NEs in the statute, there's a pretty good argument that you should qualify. That being said, the risk is just large. Tax lawyers could give opinions, that you should get it. But that opinion is really, it's not a certainty. Tax lawyers don't guarantee things. We're not insurance companies. It just means we think you should win if it was litigated with the IRS, but it doesn't mean there's no risk involved. And just in the magnitude of the risk is pretty large for investors. And so whether an investor would want to go that route or not, take that kind of risk. Some state agencies have said no. They're not going to do it. If you have any bonds issued last year, they're not going to do it. Others are now suggesting maybe we'll issue as little as $5,000 of bonds in 2021 and get you that, try and squeeze you into that 4%. We don't know what the answer will be. Letters have been sent in the IRS asking about this, but we don't know what they're going to say.
Is there any just thought that, hey, if these drawdown bonds do work, would costs incurred in 2020 be at the 3.09% and in 2021 be at 4%? Or to your comment, well, now it's all speculative, I know, but what's your thought on that?
I think the thinking is the 4% rate would apply to the whole thing. I mean, the statute says, in the case of any new or existing building which is placed in service after December 31, 2020, the applicable percentage shall not be less than 4%. So arguably, it's just one building. And so if you, qualify, even for costs incurred last year, as long as it wasn't placed in service last year, arguably you'd qualify for it. One thing to be careful of in that even if you qualify for the 4% rate, say you issued your bonds this year, if you bought the building last year and it was placed in service last year, your acquisition credits will not get the 4% rate because one of the requirements is the building has to be placed in service after 2020. Now, that rehabilitation under Section 42 is treated like its own building. So as long as you place the rehabilitation in service in 2021 or later, then it could be eligible for the 4% rate, assuming your allocation is in 2021 or you meet the issuance test. But you would actually end up with 2 different rates. You'd end up with the floating rate of whatever the rate was in when the building was placed in service in 2020 on the acquisition, and then the 4% minimum rate on the other. So you need to watch out with that either way. That's pretty easy. There's no ambiguity about the law. You just need to examine your facts on each deal to see where you fall.
Awesome. Thanks. I think I think our listeners now are experts. I certainly am. That last example was one that's come up before, and you're right. I mean, it's pretty much statute there. I mean, it's pretty clear for that one. So we're about to wrap up, but I do have one last question to ask you, Glenn. This is, one that we've always like to ask folks like you, people in the industry that might have their certain views on specific things. So the question is that long-standing question around, can a project take tax credits on a return for a project which has not received its 8609? So now I know obviously people say, no, if you don't have them, you can't put them on there. But what are your insights or thoughts on this discussion?
This was a hot button issue in the spring of last year, and we actually had some calls with the IRS about this issue. And we haven't gotten anything in writing from them, unfortunately, but it is a difficult issue. But where we got in them in our verbal discussions was that Section 42 has a reasonable cause provision in it. I mean, it's not explicit in this, but if you don't have the documents showing your 8609 showing the amount of credits you're entitled to, but you have a reasonable cause for why you don't have it, then you could take the credits on your return, attach a statement explaining why you have reasonable cause, and maybe a credit computation or something showing what you think it is, or possibly other documentation supporting why you should like your carryover, for example. And that could be, you could take the credits based, even though you don't have the 8609 yet. We did ask the IRS, could they issue guidance on this, and a regulation would take forever. We asked, and it was suggested, could they amend the instructions to the form for 8609 to address this? And we were given some encouraging, forms aren't as hard to get changed as issuing regulations or notices. On the other hand, they didn't change the form for 2021, so I don't know. But that pretty much the industry, and I think your firm and others have gone along with that. If you have reasonable cause, so by reasonable cause, it's not a given. The developer should have done all that needs to be done to get the 8609, have the package in on time, or to the best they can, or it shouldn't be that the delay is due to lack of diligence by the developer. But assuming you've done what you can and it's out of your hands, then people are taking the credits out.
Very good. Very good information. Glenn, really, really thank you so much for your time today. Really great insights. Our listeners will get a lot of great insights. And with that, that's a wrap. Thank you for joining the BuzzHouse today, Glenn, and listeners, thank you for tuning in.
Thank you for having me. It was a pleasure.
Thank you for listening to BuzzHouse. To receive a notification when new episodes are available, please subscribe to BuzzHouse, a Baker Tilly podcast, wherever you get your podcasts. For additional resources around multifamily housing, check out bakertilly.com. And if you have a suggested topic, please send them to build@bakertilly.com. That's BUILD@bakertilly.com.
The information provided here is of a general nature and is not intended to address the specific circumstances of any individual or entity. In specific circumstances, the services of a professional should be sought. Tax information, if any, contained in this communication was not intended or written to be used by any person for the purpose of avoiding penalties, nor should such information be construed as an opinion upon which any person may rely. The intended recipients of this communication and any attachments are not subject to any limitation on the disclosure of the tax treatment or tax structure of any transaction or matter that is the subject of this communication and any attachments.